And here is Samsons Take. Breaking news. Chief Justice, 2 judges lock up a nurse at the Supreme Court. 2 others go to his rescue over murder and a dozen felonies. In 2015, the judiciary was brought to its knees to purging it of corrupt elements. The country was hit with a massive scandal as 180 officials were caught on camera taking bribes and extorting money from litigants. 34 of them were judges, and Chief Justice Georgina Wood was swift in sanctioning the culprits according to law. The man who had been celebrated for risking his life to name, shame, and help the state jail greedy nation wreckers at our borders, ports, orphanages, hospitals, etc. Anas Aremeyao Anas was behind the camera that caught the judges. He would soon become public enemy to the powerful and their followers when he beamed his cameras on corrupt football gods and politicians. On 20th November 2018, he sought refuge in the High Court over a period of sustained vilification. His person and methods of undercover journalism were under severe attack. The MP for Asin Central and failed MPP flag bearer Kennedy Ejapong would blow the cover off a member of the Tiger Eye investigative team on television. Ahmed Hussein Swali was murdered shortly after. Anas Aremeyao Anas gathered and placed before Justice Eric Barr as many as 28 statements, labeling him a fraudster, thief, blackmailer, promoter of illegal mining, murderer of an MP, J.B. Dankwa, abettor of the murder of several Chinese and many other felonies. But on the 15th of March, 2023, not only did the judge deny him the 25 million Ghana cedis compensation he sought, he pronounced him guilty of all those crimes, stopping short of throwing the man he convicted of doing investigative terrorism into jail. Many joined Anas in deprecating the judgment as a travesty, which he appealed and also mounted a certiorari application in the Supreme Court to quash it. On the 28th of February, Chief Justice Gertrude Saki Tokonu and Henrietta Mensah Bonsu backed Samuel Esiedu in dismissing his application. The long wait for the judgment expected on the 4th of March ended yesterday. In the 97-page 3-2 majority decision, they hold that Justice Eric Barr did no wrong in his use of, quote, strong words, and quote, and or, quote, crudeness of his language, quotations close, because he was simply assessing and evaluating facts and evidence before him. And that's exactly the job of a judge. Anas is accused of indirectly seeking to gag the judge by accusing him of bias or prejudice, hate and personal dislike. They insist that the appropriate method to question the analysis, inferences, findings, and conclusions of the judge is by an appeal and not resort to the supervisory jurisdiction of the Supreme Court to quash the judgment. More so when this process does not allow them to go into the record of the trial. The first of the 2 grounds for the certiorari application, being that the judge lacked jurisdiction, was roundly and unanimously dismissed by all 5 judges. They argued that the fact that Eric Barr did the case as a relieving judge and would be reassigned by Chief Justice Enin Yeboah to continue the case at the request of Mr. Ejapong, at a time that court got a substantive judge, does not invalidate the judgment. And in any case, Anas did not object, but participated fully to the end. If Anas had won, will he be complaining of injustice? Justice Asiedu quizzes. They seem to advise that if he had any such complaints, he should have raised it while the trial was ongoing. Now the minority, dissent, led by Justice Emmanuel Yoni Kolendi, violently disagreed with the three. He and Justice Isufu Umoro Tanko Amadu, after referencing the judicial oath and reciting cases that cautioned judges against what the High Court judge did, cited a plethora of cases that support granting Anas's certiorari on the grounds of lack of fairness, bias, or prejudice. They praised the judge for beautifully outlining the law on defamation, but condemned him for failing to apply it and rather acting injudiciously, capriciously, demonstrating hate for Anas and his methods of journalism, and literally convicting him of crimes in a civil suit without due process, without evidence, and without the opportunity of being heard. It is an explosive dissent, but I share only a couple of the paragraphs of what will definitely dominate discussions in legal circles and the public in the coming week. First, Justice Yoni Kolendi. He says, I find it even more perplexing that a court exercising civil jurisdiction will find that the applicant, that's Anas, is guilty of having taken bribes and being dishonest, fraudulent, a cheat, an extortionist, a thief, a blackmailer, and corrupt. Equally baffling is the trial court finding that a description of Anas as a criminal, murderer, extortionist, blackmailer, corrupt, land grabber, tax evader, bribe taker, cheat, interferer in the administration of justice, email hacker, among others, are truthful and factual. He says, there can be no greater affront to the rights and honor of a litigant who resorts to the sanctuary of justice to vindicate his rights than this preconceived, biased, prejudiced, and ill-motivated views which the trial judge held of Anas even before he embarked on a trial of the case before him. Needless to say that the trial judge was merely pretending to adjudicate, even though he was already harboring these opinions of Anas and animosities against him for his work, methodologies, and prominence. He continued, I must hasten to emphasize that it matters not whether or not these statements were made within jurisdiction, as even statements made within jurisdiction may evince a latently held bias or prejudice harbored by a judge for or against a party. Then he continued, just sharing just a few of them with you. He continued, he said, that Anas is, to say the least, a victim of judicial defamation, a violation which, in my view, is more grievous, that his complaint against the interested party, that is Kenneth Japong, which landed him before the trial court in the first place. He had other very harsh words, but I conclude on this. He says that the judge's personal reservations disapproval and dislike for Anas and his modus operandi had poisoned his mind, blinded and disabled him from being an open-minded and impartial adjudicator of the matters before him. He says, what the judge did were indicative of a deep-seated personal dislike of the person and investigative methods of Anas. One would ask, was Anas on trial for murder, terrorism, or the host of other crimes that were imputed to him by the judge? Says the judge only stopped short of sentencing Anas. This type of unrestrained, intemperate judicial arbitrariness, motivated by obvious personal dislike of a citizen, in the sanctuary of justice of all places, ought to be deprecated, disapproved, and rejected in the strongest terms. The toxic, caustic, and unsavory descriptions of Anas by the trial judge is a classic example of a violent abuse of judicial power, privilege, and prerogative in the deployment of language under the guise of judgments. What did his brother say? Briefly, Tanko Amadou said, with all due respect to the judge, it is my view that it is obvious that he was actually actuated by his self-conceived notion of Anas's supposed improper investigative methods and thus discarded the core issues before him. In fact, the judgment as rendered was indubitably informed by these personal dislikes and against Anas, and not based on the law and evidence placed before the judge. From a reading of the judgment, it is obvious that the judge deliberately set up the delivery to assist the cause of Kennedy Japan. Lastly, Justice Tanko says, I must express my admiration for the judge for his elaborate and erudite evaluation of the law on defamation. While I expected that based on the law so propounded, the judge would apply same to the facts and evidence, the judge, unfortunately, did not just descend into the arena of conflict, but pursued a line of what, in my view, is an improper reliance of extraneous matters against Anas, which were not relevant in the determination of the suit, which associate Anas with criminality. This was at a stage of the proceedings where Anas was not and could not have been heard on those matters. And that will be my take. Look for the judgment and enjoy it.